Hey guys, Derek Johnson with Tatango.com. I'm here with David Carter from Innovista Law, home of the TCPA Defense Force. We're sitting down with David today because recently there was an opinion, and I'm going to get all the information about what's going on here, and this opinion affects text message marketers like you and I. So David, welcome, and good to see you again. I know we've done a ton of YouTube videos together. So explain to me, first off, who you are and why you have enough knowledge or skills to talk about, what we're talking about today.
Sure, Derek. It's good to see you again. So the TCPA Defense Force is a law firm that me and my colleagues started Innovista Law about 3.5 years ago. And we really focus here on the Telephone Consumer Protection Act and helping companies, including mobile marketing companies, respond to and deal with the TCPA. And I've been working in telecom issues for over a decade now, and a lot of my work has involved policymaking and rulemaking at the Federal Communications Commission, including, most importantly, here on the TCPA that we're going to talk about today.
So it sounds like, you know more about the TCPA than I think most people in the world. And that's my objective statement. One thing that's been interesting, and we've kind of been talking about this in our Facebook groups and on LinkedIn and on YouTube, is the kind of Warren Buffett quote that says, you never ask your barber for if you need a haircut. And because there's always some, kind of reason, why people are acting the way they are. One thing I'd like you to touch on before we get into this is maybe why, of the things we're talking about today, you may want to rely on an outside counsel rather than going to your text message marketing provider. Can you explain a little bit as to maybe why it's not the best, maybe you can get certain information from your text message provider, but why it's always best to go to a third-party outside counsel, not even the counsel of the text message provider?
Yeah, well, I think it's important to understand particularly when you're talking about the Telephone Consumer Protection Act, that it's an area that's constantly in evolution. And as we see from this decision, there's going to be a number of issues that are left open after we talk about what the D.C. Circuit has done to the 2015 order that was released by the FCC. So that decision is going to leave a number of issues open that will continue to evolve. And those evolutions will happen both back at the Federal Communications Commission, but also in courts across the country where they look at and try to determine and decipher exactly what the state of play is now that the D.C. Circuit opinion is out. And so as we watch these cases unfold and we sort of track and monitor them on a daily basis and look at evolutions and trends, I think this is an area of law where if you're maybe not focused on it on a daily basis and not watching or monitoring those trends, that you may miss kind of key developments or issues. And you may not realize, for example, that courts in New York are interpreting the decision in a way that's different from the courts in California. And so working with companies as we do across the country, one of the things that we look at often is, where might they be sued if they do confront a TCPA challenge, and what courts' opinions are going to be really relevant to that particular company. And so those, again, trends, evolutions, developments that will certainly flow from this decision are things that the majority of people and even the majority of lawyers are not necessarily tracking closely.
So it's really just kind of the specialization. TCPA, a lot of text message marketers and brands think it's, putting a certain kind of disclosure in a message, and that's all. Or making sure that the opt-in is a double opt-in. Like, it goes significantly farther than just what the software can provide, and that's where I think there's a lot of confusion. And we always recommend as a client always to get outside counsel to kind of also check to make sure what the SMS provider is telling you, syncs up with that as well. There's always everybody has their own reason why they're doing things, and you want to make sure you always get a third-party opinion, which is an attorney.
Sure. And I think also, too, that as these issues evolve, for example, the terms of service that you may provide that the consumer may opt into and agree to abide by, those terms of service shouldn't necessarily remain static for 5 or 10 years. Those are the types of things where, as changes happen in the law, it's important to keep those terms of service as updated as possible. There's certainly been, beyond this decision, there's been a lot of development in areas around arbitration and opt-out consent requirements that will continue to, I think, be informed by new case law. And so we are kind of constantly working with companies to make sure that their terms of service are updated and reflect at least what we know today as the best practices.
Yeah. And it's always changing. So speaking about changing, what has changed? So I know you said there was an opinion, and I kind of went like this because I really don't know what this opinion is or whose opinion is it. I have a lot of opinions, but it doesn't seem to be kind of sparking as much interest as this opinion. So sure. I know there was something that was submitted back in the day, and now this is the opinion based on what was submitted. So maybe just kind of break that down for the people that don't even know what we're talking about.
Yeah, absolutely. So in the starting point really for this discussion takes us all the way back to June 2015. Okay. So almost 3 years ago now. And in June 2015, again, it was under the Obama administration, the Federal Communications Commission released what it called an omnibus order regarding the Telephone Consumer Protection Act. And that order really, there had been 15, 20 different petitions from companies across the country asking for various clarification or modifications to the rules of how the Telephone Consumer Protection Act was being implemented. Okay. And so they asked for the FCC to say, look, there's a lot of ambiguity or new technologies that haven't been addressed. We have all these questions. And so in June 2015, the FCC took up many petitions at one time and tried to resolve or provide clarity on a host of different issues. That decision is interesting. They actually adopted the decision in June 2015. It took them several more weeks to finish writing it because it was so lengthy and there was all these edits to finish. So it gets released in July of 2015.
Okay.
And that sparks a series of appeals of companies that were dissatisfied with the FCC's resolution of issues. And those appeals got filed in various courts, federal court of appeals, and then ultimately consolidated into a single case at the D.C. Circuit Court of Appeals. And the D.C. Circuit Court of Appeals is interesting because it deals with so many federal agencies' decisions and the appeals of those decisions. So a big part of what that court does is it looks at these federal government agencies and determines whether or not the decisions they've made are reasonable and rational decisions, and do they comport with the language that Congress used when it wrote the Telephone Consumer Protection Act. Okay,
so the FCC created the Telephone Consumer Protection Act way back in the day, right?
Congress created the Telephone Consumer Protection Act and gave the FCC authority to interpret it and to adopt rules about how to enforce the Telephone Consumer Protection Act.
Then there was a lot of people that had questions, and they were like, we need clarifications on it. They submitted something to the FCC and said, hey, we need more information about this, or we want you to make a judgment call based on this phrase, or what does this mean or this mean. The FCC made a lot of judgment calls, or what would be the technical term for that?
So they issued a ruling and order resolving those petitions.
Okay, a lot of people were not that happy with what they said, and maybe they needed more kind of explanation on each one of those things. So then the FCC, they were kind of like, well, we made our ruling, I guess, right? Ruling. And so then a court took it up and said they were kind of checking the work that the FCC has done.
That's right. And it's important to understand that when the court checks the work, as you described it, of the FCC, it's very deferential to the FCC. So it doesn't try to substitute its judgment as if it was the telecommunications regulatory agency.
Okay.
The FCC is, and all federal agencies are expected to have expertise in the areas in which they work. And so as a general matter, courts are very deferential to those expert agencies. And they don't.
Big words, deferential. What does that mean?
Well, they try to say, if the decision that the Federal Communications Commission made is reasonable,
Okay.
and there it could have gone this way, it could have gone the other way, but they chose a path that was reasonable.
Because we think they're experts.
They're experts, and so
Okay.
I'm not gonna reverse their decision, even if I might have chosen a different path.
Okay.
I'm not going to reverse their decision as long as it was within this range of reasonable outcomes, right?
Okay.
What the Court of Appeals will do is, if something the FCC does is directly contrary to the statutory language adopted by Congress,
Okay.
then they would say you can't do that, right? That's out of bounds for what's a reasonable decision here. Or they may look at the decision and say, it just makes no sense.
Okay.
Like as a practical matter, the choice you made is not reasonable.
Okay.
It's not something that people can either comply with or live up to these requirements. And so you can't put people in the position of having to comply with something that they can't comply with, right?
Okay.
And so that's when a Court of Appeals looks at a decision from the Federal Communications Commission. Again, they're not looking to say, what I have chosen a different path. They're looking to say, is the path the FCC chose one that we can allow to continue?
Okay. So, and who brings this case to the court? Is this one person, or? And it's one case. It's not like 100 different cases, right?
Well, so the answer to that is, in this particular case, in this particular circumstances, it was several different companies that had participated in the rulemaking process and asked the FCC for this clarification, filed appeals, and there were in fact multiple appeals that got filed.
Okay.
But then, as a matter of judicial practice, those appeals got brought together into a single case that was heard and decided by the DC Circuit. So it starts as a procedural matter as several different cases that then get brought together as a single case for resolution.
Okay, so one case, and it's essentially kind of, wants, somebody to look at what the FCC has done, and not change it, but, see if it fits within the rules. So when was that submitted to the court, and how long has it taken, I guess, now to get the opinion? And that's the result of what this has happened, correct?
Yes. So the decision, again, was released in July of 2015.
Okay.
And there's a period of a month or so after the decision is released for parties to indicate to the courts that they're going to seek the court's review of that FCC decision. So they have a period of time to just file a relatively short filing telling the courts, hey, wait a minute, I'm going to want you to take a look at this.
Okay.
And then once that happens, that's then when the court will act to bring all the cases together, put them under one single case to kind of proceed. And then there's a series of legal briefs that get filed, and the people that are appealing the decision will file their legal briefs, and the FCC will respond. There'll be more briefing. And so that process goes on. It takes a couple months to kind of get through that process. And so in this particular instance, the briefing took until mid-2016. Okay. And then in October of 2016, the 3 judges that were assigned to hear the appeal held oral argument. And so that's where again, the FCC and the attorneys for the people that had appealed the decision were able to stand up and talk to the judges about the particular legal arguments, clarify questions that the judges may have, so that the judges could then issue an opinion. And so in a typical case, if you had oral argument in October 2016, you would expect a decision from the DC Circuit 5 or 6 months later. And so in this particular instance, we've been on hold for quite a long time.
Okay.
So we went well over, I heard, I don't know if this is precisely correct, but that we waited almost 6 times longer than most appeals to get this decision. So it's definitely been something that that a lot of people, not just TCPA lawyers, but a lot of companies and others have been waiting for because of how important it is to the text message marketing industry.
Wow. And when people were making these arguments, was this like a month-long process or a year-long, like the actual like oral arguments? I guess people were standing up and talking to the judges, right?
Yeah. So the oral arguments, you're talking about like an hour tops.
Okay.
Like typically they would give most cases only 15 minutes per side to stand up and have oral argument. I think in this case it did run a little bit longer because the courtroom was packed and there were so many kind of people interested in this appeal. So my colleague Martin was there in the room, and he reported back that they kind of let the arguments continue much longer than they typically do, given the magnitude of the case. But yes, in a typical appeal, you're talking most of the work is done in writing. It's submitted to the court. The court reads these legal briefs, and they come prepared to the oral argument, usually to ask very specific questions that they want answered, that they feel like weren't adequately covered. Sometimes they try to seek a level of a concession from the lawyer to admit certain issues that they think will be important to the final legal analysis that they will write. But it's a relatively, for how much work is involved in getting ready for it, it's a pretty brief moment that you get to stand up and actually have your conversation with the court there.
Wow. And are there two sides that are arguing, or what are they arguing about?
Yeah, so the FCC, so the people that are appealing have to establish for the court that the FCC acted in some way that was unreasonable, right?
Okay.
And the FCC gets to explain to the court why what they did was reasonable or consistent with the language in the statute and that Congress adopted. So the FCC is represented. The FCC has its own lawyers in-house. And then on certain issues, you'll also see the Department of Justice step in and actually also work with the FCC to do argument as well. But so you have essentially the government's lawyers versus the others.
Okay, so this is like Law and Order for text message marketing. Kind of. That's what I'm picturing in my head here.
I think a little bit different. Law and Order is usually more like there's trials and witnesses and things like that.
Okay, so no witnesses, just
witnesses.
Two people debating.
There's no guns involved usually. So it's it's really just lawyers,
a lot of lawyers.
standing and having they call it argument, but it's usually far from an argument. It's usually a very formal discussion with the judges who are going to be making the decision and kind of trying to meet their needs if they have particular questions.
Okay, so all this stuff happens. They all have their discussion, let's call it, and then they go back into chambers, and there's my Law and Order kind of reference there. That's all I know. They go back somewhere. The three judges, right? There's three of them.
There's three judges in the
and they produce what, an opinion? Is that how this kind of ended up here?
Yes. So the three judges will get together and sort of discuss their views of the legal issues that were raised in the appeal.
Okay.
And at that point in time, there's usually the sort of what's called the presiding judge of the three-judge panel. And it depends if the presiding judge wants to. He can say that he or she could say, I'll write the opinion on this case, or he can assign it to one of the other judges to write the opinion. And that will depend on any number of factors, both their work schedule, the vote, if there's a split of opinions on the issues. So somewhere in that process, they'll determine who's going to write the opinion for the court. And it can become more complicated because sometimes among the three judges, one issue will go one way, and then others, there'll be different decisions on other issues. Because keep in mind, it's not just one legal decision that it'll all come out in one legal document, but they're making a series of different decisions, right? And so sometimes
it's not like guilty, not guilty, and then it's done. This is many different counts of what they could be guilty of or not guilty of.
Right. So you will have, you might have three people that agree on one issue, and then only two agree on another issue, and then a different two could agree on a third issue.
Now,
and so
for the actual agreement, does it need to be 2/3 and then it is passed or
Correct.
agreed upon or something?
Yes, essentially in this context, right? It's either whatever legal issue is under debate, as long as two of the judges agree on an outcome, that would be the decision of the court.
And how many decisions were made total in this opinion?
So in this particular opinion, there was 4 different distinct legal sections that they were dealing with. There were 4 issues that were under appeal. There might have been a couple different arguments under a particular issue, but they really had 4 clear categories in which they were making decisions. And in this particular case, all of the decisions were made unanimously, so there wasn't a situation where you had a dissenting justice arguing a different view of the law. So
that means all the judges agreed with what
100%.
The non-government attorneys were saying, essentially.
Well, as we'll talk in a minute, they agreed with the appealing non-government attorneys on a few issues, and they agreed with the FCC on a few issues.
Oh, okay.
But in each circumstances, the judges were uniform in their view of who had won the issue.
So this wasn't a slam dunk for either side, but at least we got clear rulings, I guess, on each one.
That's right. Right. So so eventually, and again, they may have had multiple iterations or conversations about the particular appeals and what decisions they would make in the course of the year and a half they had to make this decision, right? So we don't know. We'll never know. It would never become public information whether the judges' views on the issues changed during that year and a half, or whether they sort of came out and had a particular view immediately after the oral argument, and for some reason it just took a really long time to write the decisions. So we'll never know what happened in those months that went by. Okay,
so now we're at the point that there was 4 things that were kind of resolved or clarified, I guess. What are those 4 things, and which ones are most important to text message marketing? Because I know a lot of TCPA stuff has to do with phone calling and interrupting your dinner and things of that nature.
Right.
So let's go through the 4 things, and then let's focus on the ones, if it's all 4 or all 3, whatever it is, that just focus on the text messaging.
Okay, so let me just run through the list real quick. There was a decision related to the definition of automated telephone dialing system, and our shorthand is referred to as ATDS. Most normal people would just call it an auto dialer.
Auto dialer.
So there is a key decision on that point that will directly impact mobile marketing SMS messages. There is a decision about reassigned telephone numbers and whether or not calls or text messages to a phone number that has been reassigned to a new user, whether that is a potential violation of the TCPA. That clearly affects text message marketing probably most significantly of all the different ways in which you might be impacted by the TCPA. I think that one is a pretty significant issue. The third issue is regarding the right of a consumer who's previously given consent to receive calls or text messages. How can they revoke that consent? Can they revoke the consent? What happens there if they do revoke the consent, and how does that impact potential TCPA liability? Again, clearly on point for mobile marketing.
We actually discussed that in one of the videos, I think, before this obviously opinion is how can people revoke the consent? And it was, there were some ways, but then it was kind of left wide open because this opinion hadn't come out yet, correct?
That's right. Yeah, we did talk about that in our video. And just a forecast, unfortunately, we did not get much better. The situation is not much better on that on that particular issue. So,
and then number 4. What is number 4?
So number 4 relates to a particular exception relevant to the healthcare industry and their ability to send text messages to consumers regarding a pretty finite area regarding appointment scheduling and things like that.
So informational type things for healthcare.
Yes, and so there was an appeal on that issue just by Rite Aid, the pharmacy company, appealed the issue and sort of argued that the FCC had really complicated matters because the healthcare exception for mobile marketing and mobile messages is different than the one for calls to landlines, and they argued that it was unnecessarily a confusing standard that had been created. And, I think that one's relevant, but only for healthcare people. And so I would put that sort of on the list of ones we probably don't need to spend a lot of time on
I'll have them contact you. If they're a healthcare provider, this was like the flu reminder shots and stuff, right? Like
that's right.
Okay.
So we have a whole... We have a whole e-guide on the healthcare exceptions because there are multiple exceptions, and the way in which they do and don't overlap is pretty confusing. So for people that want more information about that, I'll just quickly say this DC Circuit opinion doesn't change the law at all on that issue. So the e-guide that we have up is still the best information we have on how those particular exceptions work. And if people are interested, they should check that out on our website.
Yeah, definitely contact you. If you're in the healthcare, figure out what went on there. So that's one of the things. So, and that was one of the ones that the company attorneys, I guess, lost, right?
That's right. So that's an issue where the appeal failed. The FCC, the DC Circuit said the FCC, what they did there was reasonable, and it was also consistent with the scope of authority that Congress had given the FCC on that issue. So it was not they rejected the appeal there.
One win for the FCC over here.
That's right.
So now we got three things that our viewers that are text message marketers should be aware of, or at least thinking about. So the first one, what was the first one?
Yeah, so the first one was around auto dialer, the automated telephone dialing system. And the issue with that is in the 2015 order, the FCC had said that they would start interpreting the definition of auto dialer to extend not just to devices that had the present capacity to create these lists of random telephone numbers and send out these messages, but they would start concluding that anything that had the ability to be modified in the future to do that, to provide that type of auto dialing service, would also be now within the definition of ATDS, auto dialer, and therefore subject to the TCPA. And that's a lot of word salad that I just gave you there. But so let me try to extend to help translate this. It was argued, and the DC Circuit agreed, that the broadened definition that the FCC adopted in 2015 literally would apply the TCPA to every single person who had a cell phone, a mobile smartphone, right? So if you had an iPhone, that would be now a device that could be within this broad definition of auto dialer. And therefore, individuals would be required to have advance consent to call other people. And so, as ridiculous as that sounds, what was even more ridiculous, in my view, is that the FCC didn't argue that the definition was not that broad. The FCC essentially had multiple occasions, both at when they wrote the decision in 2015, when they filed the documents with the court, the briefs with the court, and again an oral argument to say, no, that's not, like, we couldn't possibly mean that. And the FCC never denied that the interpretation of the order that had been argued as one that was in fact consistent with the language they used. And so when the DC Circuit took that up, they pretty quickly concluded that's not what Congress meant. Congress did not mean for everyday average Americans to have to comply with the TCPA or face potential liability. And so they pretty quickly struck down I shouldn't say pretty quickly because it took a year and a half, but they pretty easily concluded when they did issue the decision that that the FCC's broad definition of auto dialer was just something that couldn't live. And so we now go back, I think, to an environment that existed prior to 2015, in which it's focused on what is the device really set up to do and capable of doing to determine whether or not it's something that gets into the TCPA umbrella, which, I will say in some ways is a win. I mean, the appeal was successful, but I think it's important to remember that before 2015, we still had a lot of litigation about whether or not a device was an ATDS.
Okay.
Particular technology like what's called predictive dialers and things like that. There was constantly a struggle for the courts to try to resolve whether a particular piece of technology was or was not an ATDS. And so returning to that landscape does provide companies theoretically with an additional defense that their device, is really humans dialing telephone numbers and it's not an automated dialing system. But I guess from my experience as a litigator in litigating these cases, what that means is that you're often going to have expert witnesses examine your technology, make the best case possible that it's not an automated telephone dialing system. But that's an issue that may not get resolved in advance, and it may be something that you really have to deal with in a litigation if you're confronted with a TCPA case.
Mm-hmm.
And so from a compliance perspective, I think that most companies will want to continue to comply with the TCPA unless they have a really high degree of confidence that the particular piece of technology they're using could not be viewed as an automated telephone dialing system. And the only way most companies will get that confidence is if someone using the same technology has gone through litigation and has sort of had a court declare that the technology is not subject to the TCPA.
Okay, and because I've seen this with like call centers where
Mm-hmm.
they'll have rotary dial phones essentially because they're trying to essentially say to people that this doesn't even have the ability to auto dial or to. And we're not talking auto dial like a person's not calling 100 people at the same time. It's that it's triggering the phone calls like back to back, or it's auto dialing for the person calling.
Right. So I think if you have a rotary dial telephone, you're probably pretty safe. That's
okay, but that was why they had to go that far, right? So if they ever got deposed, they could say this literally could never ever make an auto dialed call.
Right.
Okay.
Right, because anytime it's sort of connected to a computer system, right?
Yeah.
And the computer system maybe you have a call center and the computer system, there's a person sitting there who's going to be making these calls, and when they hang up, it suggests the next phone number for them to call. Then that's the scenario in which there was prior to 2015 quite a bit of debate. It's the scenario that kind of prompted the FCC to try to expand the definition and maybe you could say eliminate the ambiguity and just say, yeah, it's in the TCPA. And now we're going to go back to that environment. And again, I think for some companies that's good news because they might have really good arguments about why their system is not an ATDS, okay. And they will now be able to present those arguments and potentially win on them. And particularly, I think if they have a good technical expert that can explain the system and why it's not, it doesn't fit within the parameters. So I think it's good news from that perspective. It opens the door back up to a defense that the FCC had sort of closed. But on the other hand, it's not a slam dunk.
It's not like black and white. This is exactly what it is. This is exactly what it isn't. It is pretty much taking us back to kind of where we were before. Is that anything I guess could be well, you said that they limited it, but where did they limit it to? In terms of they said it has the capacity to do auto dialing. Did they say, yes, we agree, but then did they bring it down a little bit? Where was the official?
Yeah. So this is another important point to understand. So the D.C. Circuit doesn't decide then what happens, right? Okay. What it says is you can't go there. And then it's essentially back to the FCC to decide whether they want to initiate release an additional ruling and order to try to move the line up in a different way to a different point, whether they want to just let things go and not touch the issue again.
Okay.
And so this is one of those things where we really will have to wait and see what developments exist. What does the FCC do? What do the courts do now that this decision is out? And do we start to see trends from the courts kind of moving in a particular direction?
Okay.
So I think this area is certainly more gray than it was, and we'll have to kind of wait and see exactly what happens and what unfolds. The FCC, again, could decide to take up the issue, but the current chairman, again, this 2015 order was adopted under the prior chairman, under the Obama administration. The current chairman was on the commission as a Republican commissioner at that point, was not a big fan of what the Obama administration did in this area, probably is not going to replicate it, but may move in a different direction.
So who's the president or who's kind of in office can have an impact on how they look at, and address and then readdress things for the TCPA. So it's not so cut and dry. It really, opinions matter.
Opinions matter, perspectives matter. I think in this instance, Chairman Pai, who's the current chairman, is a little bit, I would say, more tuned in to the practical consequences of some of these decisions on businesses, and trying, I think, his best to create a line where businesses can operate with clarity and certainty and not have as much fear of litigation, but at the same time still protecting consumers from calls they truly don't want, right? And so
nobody wants that. Everybody's fighting, I think, to make sure consumers are protected. It's just kind of those gray areas, I feel like, where it's like, well, but my consumer gave me my number for a flu shot, and I need to help them. And there's all these kind of gotchas almost. Like, nobody wants to get an unsolicited call from someone you don't ever know. I think we're all on the same page there. Yeah. It's these kind of weird little kind of gotchas, I guess.
Right. Now, and not knowing exactly, again, we sort of think about this as people want to comply, they want to do the right thing, but they also don't want to needlessly give up business opportunities, right? And so trying to establish those points where it's meeting both parties' needs and their expectations, I think that's kind of an important focus, and will continue to be something that gets worked out here on this issue.
For mass text messaging, you're building up a mass list of your customers' phone numbers. They've opted in, obviously. And then using software to send text messages out to those people. This has always been kind of a debate, and people that aren't as educated always debate different angles. And maybe you can't even answer this, but it might be per case, but in the best, practices, should they be following, the rules of the TCPA, because that is pretty much an auto dialer?
Yeah, I'm not familiar really with technologies that would claim to be able to do mass text messaging that's not an auto dialer.
I guess if I bring out my phone and I just start texting individual people that's a non-auto dialer, right?
Yeah, I think if you're using your phone, and there's some platforms or some software that's being developed that are sort of designed to be peer-to-peer communication,
they're kind of compared that gray line,
as compared to text message marketing to a large list. So I think in that area around peer-to-peer text messaging, that's an area it's relatively new. The technology is relatively new, and we might see continued evolution there. But I think if you're talking about a brand reaching their consumers, sending them offers and discounts and things like that, that scenario, I think it would be, I'm not going to say it's never happened. I'm just saying I'm not familiar with anyone that makes the claim that their technology is not an auto dialer in that scenario.
Follow the TCPA until that changes, essentially, for mass text messaging.
And I don't anticipate that changing. Okay. So I think you could safely say if you're doing that business, you should be very focused on compliance and making sure you're doing everything right in terms of getting the consent and things like that.
Okay, perfect. So first one, not much has changed, but definitely clarification, and things could change if the FCC decides to respond and kind of update, their stuff. What's the second one?
Yeah, so the second one is around reassigned telephone numbers, which Derek, we've talked about that several
Yep.
times now. So the reassigned numbers, the issue from the 2015 FCC decision is it said that moving forward from that point, if a consumer is on one wireless provider and they turn in their phone number and that wireless provider then assigns the number to a new subscriber,
Yep.
that continued calls or text messages to that new subscriber is not appropriate, and that would be a violation of the Telephone Consumer Protection Act.
Okay, so let me explain. So business, let's just use any business. The Space Needle business, let's call it. I'm looking at the Space Needle right now. The Space Needle business, I, as Derek, opt in to receive text messages or phone calls, whatever it is, from the Space Needle business. And I then decide I'm going to move, out of country, or I'm going to get rid of my cell phone. Maybe I'm going to switch providers, and I'm going to get rid of that phone number. I'm going to give it back to, let's say, AT&T. I don't want that phone number anymore. Well, the company that was calling you, in the past, the company that was text messaging you, you're pretty much still kind of subscribed to the Space Needle text messages, that phone number, not the person, because most companies only know the phone number.
Correct.
So now when AT&T, Jessica walks into the store and she gets my old phone number, now she's essentially kind of subscribed to the Space Needle text messages. So that's this whole reassign thing, right?
That's exactly right. You described it very well. And it's about the fact that even though that number is no longer associated with you, it gets put on someone else's device, and the messages keep coming through the system thinking that they're still trying to reach you, Derek, right?
Makes sense, because I have the phone number as the record, and most of the time we have phone number as a record, and then we have name, email address, all this stuff, but the phone number is the kind of default record, and that is the thing everything else falls under. It's not the name and then, they changed their phone number. That gets much harder.
Yeah. So what the FCC said in 2015 is that when Jessica starts getting the messages that were meant for Derek, that's a violation of the TCPA, because you didn't have Jessica's consent to send her those messages.
Okay.
And
makes sense, kind of like the concept, like she didn't opt in, but that puts a lot of pressure on companies, obviously, and I think that's what you're going to talk about, right?
Yeah, absolutely. So the other thing they did in the 2015 order, which really became the problem for them, is that they created a one-call safe harbor. So they said, hey, you have one chance to find out that Jessica's not Derek, right?
Yep.
And they acknowledged in the course of this process that Jessica may never respond. Jessica may, if it's a phone call, may never answer the phone, maybe answers the phone and pretends she's Derek, right?
Yep.
But
just hangs out.
Once you've had that one call, even if you don't figure it out, even if there's no objective way for you to know that Jessica now has the phone number, should stop getting your calls or text messages, you're still liable after that one call. And so
you get one call to test, like to see, and then anything other than that, that is a violation of TCPA.
That's where the violation and the sort of potential statutory penalties and fines.
That's that $500 to $1,500 per text or call. So
correct.
It doesn't happen on the first one, but then the second, third,
fourth.
Second
and everyone after. Yep.
Okay. And we don't when we send a mass text message, or a brand does, they're not picking up the phone. Like if they get a text message from Space Needle company or business, they just look at it and go, "Oh, that was the wrong phone number." Like they're not calling back the Space Needle and saying, "Hey, that wasn't me." So I could see that being a huge problem.
Right, and so they have no obligation to text stop or do any of those things. And so what you were seeing as a practical matter is these professional plaintiffs that would go and try to gather up as many reassigned phone numbers as possible, specifically to create TCPA litigation, and sort of instead of texting stop and getting rid of the unwanted messages, they just saw every message as a dollar sign, right? As a potential claim.
Picking up old phone numbers that hopefully had signed up for a bunch of text messaging campaigns, and essentially sitting with the phone for a year and just watching Derek's text messages come in, and essentially a professional plaintiff is going then and suing or threatening to sue those companies and collecting, and really that's what their job is.
Correct.
Okay. Or a side hustle, I guess you could say.
Yes. That's at least their hobby.
Okay. So, what a great hobby.
So that was the situation. Okay. And, what the DC Circuit said is, look, the one call safe harbor is not reasonable because you, FCC, acknowledge in your own orders and in multiple orders since then that there is no technological way to ensure that one call is enough. So you can't create a safe harbor that's not actually safe. Okay. And so the DC Circuit said, because your safe harbor is irrational, then we have to strike down the whole thing, because it appears to us that you would not have imposed liability on reassigned numbers if you had known that your one call safe harbor was going to be struck down. Those two things came together, and we believe as an agency you wouldn't have reached the first decision if you didn't think the safe harbor was going to be effective. Okay. And so we're going to strike down the whole thing. So what that does is I think a couple things. One is it at least returns to a situation in which you can argue that the consent that Derek gave me is still good enough, and I shouldn't be held liable to Jessica. Okay. And so it creates a situation in which you can make those arguments again to the courts, and then it gives
you like a little defense, a little something that at least there's something there to argue,
right.
If that happens.
And some courts had agreed in the past that as long as you had the consent from the person that had been subscribed, that you weren't going to be held liable. And particularly when the person who's receiving the messages could just text stop and get out of it, right? So It's not that much burden to have them text back one time and put an end to it. So why are we going to award them lots and lots of money for not doing the thing that would be obviously the most rational thing to do, right?
That brings up a good point too, just from a strict text messaging standpoint, is your messages. Now the CTIA, they say that you should have stop in the message once a month or something like that, which I think is good. And if you have the room, put it in there all the time, I believe. Just because of these issues, you always want to give, the instructions for people to opt out if somehow they got in the list, somehow they got an old person's phone number. One thing we've also seen is make sure that when they respond back to the SMS campaign, that the response back to them says the opt-out instructions. Because we've seen a bunch of times, we see people, maybe it's a reassigned phone number, and they get a text message from someone, and they go, who is this? Mm-hmm. And if the response says, hey, thanks for your response, we'll contact you or something, then they get frustrated. And I think when people get frustrated, that's when they go and talk to an attorney because they're like, I cannot stop these messages. I don't know who they're coming from. That's why identification. So in your messages, put the brand name, put, text help, for help, stop for stop. And then, put stop in every single message. So whatever they're trying to do, or they're trying to figure out who's text messaging them, they always see stop there. And then you kind of have a defense as well. When somebody goes, well, I couldn't figure out how to get out of a messaging campaign, and you have 50 messages with stop every single one, and it says, please, reply stop, and they just never did. And that seems like I feel more comfortable with that than, hey, you should have known how to reply stop to a text message.
Sure. Yeah, I think that, the more times you can show that you gave them clear directions and instructions on what is a reasonable way to get off the list, and the more times they ignored that, I think, again, it's going to help you if you do confront a particular instance of litigation. And like you said, most people are going to be reasonable and rational, and if they can get it done quickly and easily, they're not going to waste their time and going down and finding a lawyer and dealing with those issues, right? So
they just want to get off the list. That's their main goal.
Right.
Okay.
And they don't want to get off the list and then find that you start bombarding them again without permission. So
that's a key one. Make sure that your provider, when they reply stop, is actually opting you out. We've seen many lawsuits before where the consumer replies stop. They even receive a message back saying you've been opted out, but there's some kind of hiccup with the system. and it does it opt them out. So all we always say is test, test, test all the time.
Yeah, exactly. I think that's good advice. So the other thing that this decision will do is it will, I think, put additional pressure on the FCC to move forward with this proposal that we've been talking about, and they've been talking about potentially creating a reassigned numbers database that would capture all the reassigned numbers from all the different carriers. And so that issue is something that the new Chairman Pai, has been working on. He's already solicited input from the industry about what the rules should look like. As you know, Derek Tatango and a lot of your great clients signed on to provide comments on that, which the FCC has noted and actually adopted several of those recommendations in its next proposal. And that next proposal, kind of fortuitous timing, it's going to be considered later this week.
Oh, cool.
It won't be a final rule. This will be one more round, opening up one more round for companies to weigh in. And so, I encourage you and customers and other people in the mobile marketing space to really help the FCC do the right thing here. Pay attention to these opportunities where they're asking for input from the ecosystem, because that's your best chance of getting reasonable, rational rules and avoiding the situation that was created in 2015.
Yeah, because FCC is nice people, right? They're just trying to figure out how to protect consumers, and they're trying to kind of blend, the best of both worlds, into one. They're not mean people. I think people think the FCC is mean people sometimes. At least the things I've seen, they're trying to protect consumers, and sometimes they don't even know about the things that, when they do something else, spawns from that thing.
Yeah, and I think if you keep in mind, unwanted calls and text messages are the largest consumer complaint issue in the country. It's the thing that the FCC gets the most complaints about. It's the thing that Congress gets the most complaints about. And so they're trying to respond to those vast number of consumers who, and of course, Congress then wants the FCC to be responsive to those issues. And so you're sort of trying to counterbalance a pretty big tidal wave of complaints. And if the industry of platform providers and brands are not engaging with the FCC, not giving them information about what's really happening in the real world, not explaining to them the potential cost benefit ratios of how expensive it would be to do certain things versus do other things, then the FCC is left with really a one-sided view on these issues. And I think we have seen, and many of the commissioners have expressly said, we need more industry participation if we're going to create fair and balanced rules here. And so for me, that's why it was so important to work with you guys and others in the industry to kind of provide a voice on these issues. Because if the FCC doesn't have a record, they can't make a decision, right? And so if the record only reflects one viewpoint, that's the way they have to go.
It's millions of viewpoints because it's all the consumers, and a lot of brands aren't stepping up, or they don't even know that this is happening, or SMS providers. So if you are a brand or an SMS provider, contact myself, contact you. And it most of the time it's just adding your kind of signature voice to kind of what has already been produced. It's not that, unless you think completely different than the industry. But I think most people in the industry are feeling the same in our industry. So it's really just kind of saying, hey, I agree with what they're saying.
Right. Yeah, exactly. Like as we did on the last round, we try to make it easy for companies to weigh in without having to incur the costs and expenses of writing their own separate set of comments and things like that. And I think the more we can do that, and the more that, either in that environment or through trade associations they may be part of, but getting their voices on the record really does help the FCC both to make better decisions, but also to be able to justify decisions that are a little bit more balanced, I would say. So,
and the issue right now with this whole kind of reassign type stuff is there's no real central database. It's not really accessible as much as it should be. It's not publicly accessible. Like, there's just not like a good solution for this reassigned phone number thing, and that's what everybody's trying to figure out right now is what is that solution?
Yeah, and so I think it's important to recognize there are several, at least a few different commercial solutions where people try to provide this information, but there's no mandate for the carriers to provide data to those solution providers. So
or accurate data, like it's piecemealing kind of everything together. There's not a bulletproof solution that I can guarantee that you don't have a reassigned phone number.
Right, and so that's the issue, and that's the issue the FCC is trying to address by really imposing some additional reporting requirements on carriers. So when a reassignment happens, accurate data is provided, and that you and your customers can really rely on that data without having to go reinvent the wheel. And
that's good for everybody. That's good for consumers, good for us, because obviously we don't want to send text messages to reassign phone numbers. That doesn't help anybody.
Right.
Okay, so that's the second one, and the third one.
Yeah, so the third issue is relating to consent revication, or once you've given consent, you want to get off the list, right? Okay. You want to stop.
I like the smaller words than the revocation. I knew right when you said that, I was like, I know he's gonna come up with a smaller word for Derek here.
So getting off the list, we'll call it getting off the list. And so what happened in 2015 in this order, the FCC said consumers need to be able to get off the list any way they think is reasonable, right? Okay. And so if they obviously can go through the standard texting stop, but perhaps that's not the only way they should be able to get off the list. Okay. And this issue is a little, let me just say, I'm a little surprised the way this issue came out. So one of the arguments that was made in the appeal is that the FCC had, by saying you had to honor reasonable opt-out request, had essentially taken away from brands and platform providers the ability to contract with the consumer to revoke consent only in specified ways, right? So you could put into your terms of service, if you want off my list, here's two ways to do that. Text stop,
apply stop. Yeah, okay. Yeah.
Call this phone. And on appeal, they argued, you had taken away that ability to put those restrictions into our contract. And so that's
because they said you could do it any way you want, as long as it's reasonable. And reasonable is in quotation marks because that
no one knows what that means.
Okay, so and a lot of times I say, reasonable for me means just reply stop, or maybe go to their website and click the unsubscribe button, put in my phone number, something like that. Some people, maybe even professional plaintiff, let's say, would think that going to a store and asking the 16-year-old employee that just got hired, hey, I want to opt out of your text messaging list, that would be reasonable. Or just yelling outside the store, I want to opt out. Like, where is the line? And I think that was a lot of the issue for a lot of these brands is people were testing that line to figure out where they could make some money.
Right, and what is it that the brands really have to do to train employees and do all these sorts of things? So, what the DC? So, interestingly enough, in a footnote in their brief, the FCC suggested that they hadn't really taken away the ability to provide in the contract what would be reasonable methods.
Okay.
And I find that interesting because the courts are not really supposed to make decisions based on footnotes in briefs.
Okay.
They're supposed to look at what the FCC actually said in its order. And the order doesn't sort of even discuss or acknowledge the potential that you could have a contract or terms of service with your customer, and that would be sufficient to kind of define what would be a reasonable opt-out methodology. So me personally, I found it really interesting that the DC Circuit sided with the FCC based on a footnote in a brief, because I find that to be a sort of unusual way to go about evaluating this issue. But that's what happened here. And so the DC Circuit said that what the FCC had done in this area was reasonable, that it would not be overturned. And I think this is an area that's going to be ripe for continued fights, because I think that people are going to debate, what did the FCC really mean in their footnote when it's not in the order? Can you really impose restricted types of opt-out requirements through a terms of service? Does it have to be some other type of contract that actually shows the consumer understood that they only had these 2 or 3 options?
Okay.
I think this area, we're not done with it. I think it's going to be back as a hotspot. I think you might see the FCC actually do something proactively here and clarify what their intentions are and what's an appropriate way to address this on a contractual basis. I think you will certainly see courts divided about what this issue really means in practice. So for me, and I think it's to clients, first I would say you should look at your terms of service and you should consider making it clear in your terms of service what opt-out methodologies you regularly monitor and sort of have available for consumers. That will certainly help you. It won't hurt you to do that, right?
Yep.
And the more you can show that you're providing them with alternatives or reasonable ways to opt out, the more likely it is that courts are going to say that other ways were unreasonable. So that's an advantage, right? Because you can say, look, I gave them 2 or 3 clear ways to do it. They chose to send me poetry that never used the word stop. They must have been doing that for a reason, and it wasn't because they really wanted it off the list, right? So when you can start to show
and just so you know, because I think you and I know what we're talking about, is people were, again, these professional plaintiffs were responding back to text messages that very clearly said, please reply stop to opt out, and they would reply back with crazy sentences about how they no longer wanted to be part of the SMS campaign, and they used your big words, revoke their consent. And most SMS providers only do stop, unsubscribe, quit, the CTIA required, and even the carrier required ones. So they were trying to kind of game the system essentially. And
some really were writing poetry.
Yeah.
So those are real life examples of people trying to game the system. And I think that what we will see is, again, if you're providing reasonable methods of opting out and you see people playing these games, I think the courts are going to feel more empowered to decide early in the litigation that was unreasonable behavior, and that the brand and the texting platform is not going to be held liable when it's clear you're trying to circumvent the process, right? So I think that's in some respects is good. To me, the legal issue is whether or not that the terms of service will be able to be definitive, that you can only do.
Okay, but that still hasn't been decided yet.
There again, the language suggests that you're empowered to do that, but I think the language, there might be fights that get lodged on that issue in the future.
But for SMS marketers, make it simple for people to opt out. Keep reminding them how to opt out. It goes to more of a defense, where if something does come up, you at least have multiple times you've told them how to opt out. Review your terms and conditions, obviously, for instructing people on how to opt out. I always tell clients, if somebody wants to opt out, you want them off your list. It's not a list size competition here, unless all those people always want to be on their list, and they're prompted, they're even encouraged to text opt out, and they just don't. Those are the clients you want on your SMS list. This gray area of like, well, if I said reply stop, they would do it because they don't want to be on my list. That's when you're like, yes, those people need to be off your list. Those are the people you do not want as your text subscribers.
Yeah, I think that's right. I mean, I think in general, if you just step back and you say, look, like, we want to reach people that want to be reached. We want to get messages to people that are interested in hearing from us and that are going to be responsive when we send them messages. And we don't want to do stuff that's going to just anger people or make them upset with us, because those are the people that do over time become your plaintiffs. Even, they may not be people that are gaming the system at all, right? They may be people that really, And so I think as a general approach, if you think, look, I want to help the people that don't want to be here to get off, make it easy for them, because at the end of the day, that's probably the most effective strategy for risk mitigation.
Okay, so it does seem like there was a lot of clarification, but a lot of stuff has been passed back to the FCC, especially on the text messaging side. Some interesting things, some interesting developments. it still feels like, and I think we're at like an hour right now discussing this, and we haven't even gone real deep, I don't think. We're kind of touching the surface. It brings out the point of when these things happen, and they're happening all the time. This is why you have a TCPA attorney, is because they are monitoring what you're doing. They're keeping you updated. This is a full-time job, what you're doing. Building software is a full-time job for me. You don't have time to build software. I don't have time to do what you do. I think it highlights the fact that there is huge value in having a third party, not even inside counsel within your own brand. It's really somebody that just lives and breathes TCPA. Like, I live and breathe text messaging, and I don't have much time for anything else other than text messaging. So I know how you are.
Yeah. I think, again, these evolutions are sort of constant. Sometimes, this is a major one. You don't get these types of decisions every single day, but what you do get is a lot of follow-on decisions from courts where you'll start to see whether everyone is interpreting what the DC Circuit said in the same way, or, as I predict, there's going to be a couple areas where different courts view it differently, and it's understanding when that happens. How does that, again, impact your business? What changes do you need to make? And kind of constantly evolving to make sure you're really keep focused on the text messaging. Don't have to divert a lot of time and energy to defending a TCPA case that could have been avoided.
Okay. And I know you guys have a bunch of resources on your website. How do people contact you if they want to get a TCPA attorney?
Sure. So our website is tcpadefenseforce.com. When you go to our website, there's click a button. You can send in a message to set up a call. You can also, our email addresses and things are available on the website, and people can feel free to reach out if they'd like to talk more.
And there's a bunch of resources too, like guides, webinars. It is a great resource for TCPA. So I highly recommend everybody go there. And you have a great newsletter Derek. As well too, right?
Yeah, I would encourage people to sign up for our blog. We usually put out a couple pieces every week where we talk about some new development or something that's happening. We follow both stuff at the FCC and in the courts on a regular basis. And so if you want to kind of just raise your awareness level a little bit so you start to see what are issues that people are confronting, it's a pretty doesn't require a huge amount of time commitment to kind of just stay up to date on that.
You guys are always I consider Tatango pretty up to date. Like, we put out stuff pretty quickly. You guys are always beating us on the TCPA stuff. So, and I think that comes back to the focus side. So I thank you for that, and I thank you for educating everybody out here. And hopefully we'll do more videos soon. And have a great week.
Yeah, thanks, Derek. Good to talk to you.
Talk soon.
Okay, take care.